and thank you very much for coming tonight. I'm particularly pleased to see so many young people who are engaged in the right to life issue, and it speaks well of the future. I mentioned to Joe Scheidler, and if you don't know that name, you haven't paid attention in the right to life movement for the last 50 years, if you even are that old. But I said to Joe earlier tonight that, did you notice everybody here tonight is younger than you and me? And Joe's response was, everybody's younger than me. When I was thinking of my remarks, I was thinking about the fact that just 3 days ago I bought a Mac Pro notebook from Apple Computer, and I don't know how to use it. And a friend of mine said, you won't learn just tinkering around. Go back to the Apple store and get the book, The Missing Manual. So I went back to the Apple store, but this book is about that thick and that big. And it reminded me of what AUL is about. AUL needs the missing manual because AUL has such a rich history and has started the careers of many wonderful lawyers and others who are engaged in the right to life movement today. I see Bert Balch out here, who was the first law clerk we ever had. We hired him. He promised to work for the least amount of money that we would pay him, no matter how little it was, and at the end of the summer he said, I'll give back anything I haven't used. Few people know that Americans United for Life got its start in the East. The Buckley family and others were prominently involved in it, moved to Chicago, and the right to life movement, I would have to say, after Roe versus Wade, was somewhat in despair. But AUL had this tremendous board of directors drawn from some of the leaders in ethics, medicine, and law that regularly met, and probably the most active attorney in the pro-life movement at the time was a man named Dennis Horan, who was the chairman of the board of Americans United for Life. And he would say regularly, and write about this, that what the pro-life movement needs is a legal defense fund, a legal effort to take on the other side. Because up until Roe versus Wade, virtually no legal action was taken on behalf of the pro-life side, on behalf of the unborn child. And Dennis Horan was determined to start that, attempted to raise money, couldn't raise money, and then one day I was a law clerk for him when he was doing activism on the pro-life movement. I was just in law school. But Dennis Horan called a meeting at the AUL office. And at that meeting was Dennis's wife, who's also an attorney. Dennis was a very prominent attorney in Chicago, head of a law firm, the only trial practice instructor at the University of Chicago, very prominent. But at the meeting was Dennis, his wife, and a couple of other attorneys. John Gorby, I want to mention, who was a professor of mine at John Marshall Law School. And I was there as this young law school kid. And Dennis said, okay, today we're announcing that we're starting the Legal Defense Fund of Americans United for Life. And the first project of that group was to interpret into English the decision of the German Supreme Court, which had just come down, turning away the notion of abortion for the Republic of Germany. And then we began our real legal activism. Dennis Horan had written the original parental consent laws, spousal consent laws, informed consent laws, all the individual laws that were litigated later on in the courts. And the Legal Defense Fund was started in order to encourage legislators to pass good legislation that would chip away at the basis of Roe versus Wade, and then we would litigate that legislation in the courts. There wasn't an Alliance Defense Fund and some of these other activist groups that are alive today to do that. So it was all done by AUL in the early days of the right to life movement after Roe versus Wade. One of the first things the abortion people wanted to see after Roe versus Wade is free abortion for everybody, but certainly for those who couldn't afford it. And so you had many state officials that would just proclaim that they would fund abortion. And the federal government under Jimmy Carter was all too happy to fund abortion. And we began, as AUL, contacting various attorneys general saying that we'll be glad to defend your law in the courts. And we actually did that. One of them I'll single out is the Illinois law prohibiting abortion funding, and that case was tried in the lower courts. We were intervening in that case as real parties. The case was lost at the trial court. All cases on abortion at that time were lost in the courts, at the trial court and at the U.S. Appellate Court. I see Bob Destro here, and he was litigating those cases and knows very well all this history. But all the cases were lost because abortion was supposed to be the right that trumped all other rights. Whatever you posited as a greater right, First Amendment, whatever it was, it couldn't be greater than the right to abortion. And so we litigated that Illinois case. It was lost in the Seventh Circuit, and the Supreme Court took jurisdiction of that case, and it was going to be argued in the Supreme Court. While that case was being litigated, Henry Hyde, one day on the floor of the House of Representatives, without any planning, without any strategic help from the outside groups, introduced an amendment to cut off all federal funding of abortion. And that passed that day. And it sent chills through the abortion movement, and through the pro-life movement, it was the first sign of real hope. And Dennis Horan, the chairman of the board of Americans United for Life, said this case will be litigated in the Supreme Court. When it's challenged, after it passes the Senate, if it does, we have to be ready wherever they challenge it to defend it. So Dennis and John Gorby and the other board of directors that were lawyers, Victor Roosevelt, planned out how to defend this in the various courts. And we actually had lawyers on call in various cities throughout the country, so no matter where the Hyde Amendment would be challenged, we would be able to defend it. And the abortion groups, I'm giving you the truncated history of this, but the abortion groups challenged it right after it passed the Senate in New York, New Jersey, and in Washington, D.C. And we had attorneys ready to go into court to move to intervene, that is, to become a party to the case, just like the federal government was and the abortion groups were, in New Jersey and New York. Dennis Horan and I flew to Washington, D.C. to defend the case there before Judge Sirica, the Watergate judge. And the ACLU, of course, was forum shopping, the ACLU and its abortion proponents, forum shopping to make sure they got the right judge. That's why they filed in several places. They finally found a judge in New York City where one of the cases were filed. Was his name Dooley?
Dooley. John Dooley.
John Dooley. And he was militantly pro-abortion, I can tell you that, but he was a kind man, and he let us intervene in the case on the novel notion of intervention that lawyers will see as quite novel. We intervened on behalf of Henry Hyde, who was the chief sponsor in the House, and the two chief sponsors in the Senate, as you heard, Buckley and Helms. And the notion of intervention was that these were legislators who sponsored this and therefore had a right to defend it. But the judge let us in, the other side was outraged, and we tried that case in New York City, and of course it was lost. But in the meantime, while that case was being tried and dragged on, because that judge was in no hurry to finish that case, he had already issued a preliminary injunction against the Hyde Amendment, and all the states that had laws, you had federal judges that had issued injunctions, so everybody was funding abortion. But the United States Supreme Court had taken that Seventh Circuit case that AUL was involved in and was going to hear that case. When the decision came down in New York City on the Hyde Amendment, without us even filing a jurisdictional statement in the United States Supreme Court, the Supreme Court on its own motion brought that New York case up and took jurisdiction of it in the United States Supreme Court. Then they consolidated that case with the Illinois case. So the Americans United for Life was involved in two cases and had two cases before the United States Supreme Court to be consolidated for argument. What I think is so important about the role of AUL is not just the foresight in planning all this out, and I'm just mentioning the Hyde Amendment without talking tonight about all the other state litigation, parental consent, spousal consent, all that litigation that ultimately bore fruit. But in the issue of funding of abortion, that case was going to be defended in the United States Supreme Court by the Carter administration. And needless to say, we had no faith in the Carter administration, which had hired as one of the White House counsel, Sarah Weddington, who was the attorney on Roe versus Wade. And so we had no faith they would argue this case correctly. And so we were talking with the Solicitor General's office in preparation of preparing arguments as to how they were going to defend that case. And we could see that they were not going to win that case. Their theory of the case, I won't go deeply into it, but would have required the Supreme Court to overturn Roe versus Wade, and we knew they weren't in a mood to do that. So AUL got Henry Hyde, who was at that time on our board of directors, to demand a meeting at the Solicitor General's office to talk about their brief. And we marched over to the Justice Department, Henry Hyde, Dennis Horan, John Gorby, and myself, and had this knockdown, drag-out argument with the Solicitor General, telling them their brief was wrong and they had to adopt our theory in the case. And here was the author of the amendment telling them that. And they gave in. And we argued the case on AUL's theory of the case, which was to say to the court, we don't agree with Roe versus Wade, but you don't have to overturn it. You can still overturn the notion that there should be funding of abortion. There's no equal protection right to funding, etc., etc. And that's why the case is so significant for AUL, because it was AUL's legal arguments, which AUL Board of Director Victor Rosenblum presented in oral argument before the United States Supreme Court in Harris versus McRae, and won the day in a decision that was 5-4, with the Supreme Court ruling in the majority. And one final footnote to that case. On the day that case came down from the United States Supreme Court, the Hyde Amendment was being debated on the floor of the House of Representatives. And the American Civil Liberties Union, which stands for freedom of the press, lied in their press release and in every press interview to say that the decision of the court coming down on that day was to upend the Hyde Amendment and overturn it, and they did that because the votes were eminent on the floor, and they were able to convince many members that the court had just ruled against the Hyde Amendment, and they should vote it down on the floor of the House of Representatives. And I can remember talking to the reporter from the Washington Post. If you look back at the historical record on the first issues of the papers that came out the next day, all of them had it wrong, saying the court struck down Roe versus Wade, even the New York Times, except for the Washington Post, because the Washington Post reporter said everybody says it was overturned. And I said, get the decision, read it to you. I was reading paragraphs from it. And the guy said, I'm putting my reputation on the line, and I don't even know you. And this was a prominent reporter. They reported it correctly, and the end result was that Roe versus Wade, was that the Supreme Court refused to extend Roe versus Wade and overturn the Hyde Amendment. And the victory for that is laid at the feet, I think, of Victor Rosenblum, Dennis Horan, John Gorby, and these giants with Americans United for Life. And the people in all the family groups around the country, the pro-life groups, we had to raise more than $250,000 to litigate this case over the years. All the pro-life groups gave money, and so that victory belongs to all of them who so much as lifted a finger to make that a success. Thank you very much.